All right, so today is going to be a very interesting session because we have a convincing lawyer with us today, and we are very honored to have Mr. Cannis Seng from BR Law with us, and we're so excited to have Cannis with us today. So, welcome, Cannis. Thank you so much for appearing on our show at the PropertyLimBrothers podcast. So, thank you once again.
You're welcome.
Yeah, so
Happy to be
probably
here.
Cannis, you can probably just give a brief introduction about yourself. How long have you been doing law, and then a little bit about background, right?
Okay, I'm a property lawyer with BR Law Corporation. I've been doing this for 10 years.
Right.
So after a while, you get used to the various matters which happens in property transactions. So
Right.
I'm happy to be here to be sharing a lot of this knowledge. I've been doing conveyancing for 10 years.
Right.
And I was doing a little bit of other things in between, but
Right.
basically conveyancing.
Right. So
Yeah.
mainly majoring in conveyancing.
Yeah.
Right. And on average, maybe you can let us know, like, for your daily scope or your monthly scope, right? How many cases do you handle, like, on a monthly basis?
On a monthly basis, right now I would say easily we handle around 100 to 200 cases.
Right. Of buying
every
and
month.
selling.
Yes.
Right. So definitely you have seen like a lot of cases, a lot of different kinds of um, different situations and stuff like
Correct.
that. Right. Okay, great.
Correct.
First question is that when buying a resale property and after paying the 1% option fee, because once we pay the 1% option fee, the deal is sealed technically.
Yes.
Right. And before paying the 1% option fee, what are some of the good practice as a buyer to look out for? I mean, what should be the few things that we should check first before we put down the 1% option fee?
Some of this actually, fortunately, your property agent will actually cover a lot of this for you already.
Right.
So one of it is who are you paying that 1% to?
Right. Right.
Okay, that I think is and I believe it is part of industry practice,
Right.
whereby your agent will show you some evidence that, hey, this is the property tax, or
Right.
they would do
In-list.
in-list title search.
Right.
So okay, this is really the owner.
Right.
So when you issue this 1% check to this name,
Right.
you are safe. It's not some other person
Right. Right.
that is selling this property.
Right.
So that I think is the first part. And the second part is that because all of the contracts for purchasers are always geared towards caveat emptor, buyer beware.
Right.
Okay. And also as is, whereas all this basically means is that you buy the property as it is, where it is, and
Right.
if there is anything that breaks or leaks, too bad.
Right.
Okay, you might not see the termite nest, but it is taken under the law that after you have signed off on the option to purchase, you will know about it and you accept it as it is.
Right.
So it's very important that you are willing to accept the state and condition of this property.
Right. Because it's a
Um,
resale property.
precisely.
Right. It's not a brand new from developer. There's
Correct.
no defect liabilities and stuff.
Correct.
Right. And that has to be done. That means to your satisfaction, you have to look at the property. You have to
Correct.
be willing to accept that as caveat emptor before you even pay the 1%.
Before.
Right. Because once there's an exchange of the 1% with the signed OTB by the seller, is a done deal. Right.
Correct.
And we sometimes get this kind of question, sometimes when a buyer they write off the 1% check to their own representing buyer's agent, and the buyers they given instruction to them and said, hey, okay, I agree, I agree to the price after negotiation verbally with the seller, and now I'm writing a 1% check, and then the buyer agent delivers the check and then exchanges for the OTP.
Correct.
And coming back, if before the check is even banked in,
Yes.
and the buyer changes their mind, but the exercise OTP is already given to their buyer's agent, can they still back out from the deal?
Okay. So long as the buyer you have the signed option to purchase in front of you or in your agent's hands, the seller is bound.
Right.
Yeah.
And you are bound as well. Right.
Correct.
And as a buyer, are they allowed to stop the check?
As the buyer, what can happen? This is a balancing of what is the law and what is practical.
Right.
So if let's say the buyer, let's say you are the seller, you receive the 1% check, what happens from there? Suddenly the buyer doesn't want to buy the property,
Right.
and you bank in the check and it doesn't clear. What is your legal recourse? You can technically sue the buyer, okay, for at the very minimum the 1% back,
Right.
because it's quite clear law that if I give you a check and the check is dishonored, then what will happen is that you can sue based on that. But there is a very strict timeline that follows once you present the check and the check is dishonored.
Right.
So that is it's within like days.
Right.
Yeah. So if you bank in the check,
Right.
you must quickly prove that the check hasn't cleared
Right.
and submit all of this as evidence to your lawyer
Right.
for them to initiate
A
legal
recourse.
proceedings.
Right.
Yeah.
Right. To claim back from the buyer.
Correct.
Right. And actually, in the eyes of law, the buyer's agent technically being instructed the buyer to deliver the check. They actually have that same kind of they're basically an advocate of the buyer, right?
Correct.
Right. And
The representative.
their representative.
Yes.
So when they exchange it and then they collect the exercise OTP on their way back,
Correct.
technically the deal is done, right?
Yes.
Right, right. So I think as a buyer, the important thing is that make sure that you're very clear that you want to buy this property.
Correct.
Before you even write the 1%.
Yes.
Because
Absolutely.
I mean within the next 24 hours, if you have any remorse, you want to recall back. Technically it's not possible. You set yourself into a
Correct.
legal kind of binding stuff.
And similarly, if there's seller's remorse,
Right.
because we see that also.
Right.
So generally, once you have signed off on the option,
Right.
as a seller, you have to continue on with that deal.
Right.
Okay. It doesn't help if you so-called, but I didn't bank in your check.
Right. But you signed on the OTP.
Yeah. So long as you have signed on the option,
It's done.
you're bound. You're bound.
Right. Right.
Yeah.
Right. Okay, great. I think that answers a lot. And end of the day, I think it's still a willing seller and willing buyer kind
Correct.
of thing. And everybody wants to buy and sell their properties in a very fruitful and happy
Correct.
manner, right? Right. So I think the next question will then be of course the best way, the best way as a buyer to ensure that the size and the square footage of the property definitely will be via the in-list SLA check with the
Correct.
Singapore Land Authority.
Correct.
Is there any other manner of verifying the size and stuff like that?
Virtually none.
Right.
One of the things that we would flag out is that on occasion, let's say if you are this diverges a bit.
Right.
Let's say some of the shop houses
Right.
or some of the landed properties and things like that.
That's right.
Okay. It's always taken that in-list will give you what is the certified land area.
Right.
But then sometimes some of the response that we get
Right.
is that, hey, look, because for whatever purposes, I sent in my people to check
And measure.
the area, and they measure the area for the purposes of renovation.
Right.
And they told me that it's not this area.
Right.
So this usually only happens if it happens, because in-list is really very accurate.
Right. It's based on the land title.
Correct.
Right.
We have only witnessed one or two instances whereby it's things like shop houses,
Right.
whereby there was this discrepancy, and some of this discrepancy might be because of the fact that some of these common corridors and whatnot, might have been moved,
Right.
might be included in the area count and things like that.
Right. Right.
Yeah,
Right.
but for private property, for landed
Strata.
property, strata it's basically unheard of.
Right.
Strata,
right. It's usually very accurate.
Correct.
Right.
Yeah. So these are the two exceptions that I just want to flag up.
Okay. Great. And then again, of course, the best way will be to purchase off SLA website
Correct.
to get the in-lease,
Correct.
so that you know the exact size of the property that you're buying. And how about usually buyers will have this question, when they buy a property in the midway, and they'll receive actually a letter from SLA, and they say that, hey, somebody actually, there's a caveat lodge,
Yes.
right? So maybe Cannis can explain in a very simple form for our audience, like what does it mean when a caveat is lodged?
Okay. A caveat, it's sort of like a choke on the unit,
Right.
you know. So it's a notice to the world at large that you are buying this property.
Right.
But what is additionally very common, and there is almost always no need to worry about it, is because let's say after you have bought this property, and then because you're the buyer, I've lodged a buyer's caveat for you on this property. What happens thereafter is that you suddenly receive a letter from SLA,
Right.
okay, notifying you that somebody has lodged a caveat
Right.
on this property. So it's a very official looking letter,
Right.
okay, and then they say in very official words that please contact your lawyer,
Right.
okay, or to inquire about this matter.
Right.
So what happens is that because I would say easily 90% of purchasers will also take on a bank loan. So when you take on a bank loan, we also have to lodge a further caveat.
Right. Just the bank lodging
for the
a
bank.
caveat. Right.
Yeah.
Right. Because
So
they loan you money to buy the
Correct.
property. Right.
So generally there isn't any need to have concern. It's because if you look closely, you'll realize that, hey, this other caveat is lodged by the law firm acting for you in the purchase
Right.
for the bank.
Right.
Yeah, but usually we first see that first official letter and we're like, call the lawyer.
Right. So actually, if you receive the SLA letter saying that a caveat has been lodged, no action is needed. Basically, it's just
Precisely.
for your reference.
Yeah, but look closely because you could be the 99, you could be the 0.001% of cases whereby,
Right. somebody contests.
somebody is contesting it, or some nefarious practice of this property has been sold to A and B and C
at the same time.
Right.
Yeah. Right.
So just look a bit closely, examine it a bit closely to
see who lodged the caveat.
to see who lodged the
Right.
caveat.
Make sure your name is on it.
Correct.
Right.
Correct.
Right. Okay, great. So as a buyer's point of view, when you buy a property, naturally you will be the person that lodged a caveat against the unit. And
Yes.
Of course, your bank that you are taking the loan from will also lodge a caveat
Yes.
against the unit, right?
Correct.
Okay, great. So that's great information, because most of the buyers and sellers will be alarmed sometimes. Hey, why did I receive this letter and stuff like that? Okay, so we also have another question relating to purchase, and I think this question has been very common because nowadays with ABSD in place,
Correct.
A lot of sellers that are currently selling their place, they want to make sure that their place is sold and sold to a buyer who have successfully exercised the option for their current home before they feel safe to actually put down the option for the next home. Because
Correct.
especially in this kind of flow, the main objective is that you do not have to pay ABSD on the next property, right? So just to give you a bit of backdrop, so let's say if you're selling your current property, at the same time you're concurrently looking for your next property, in order not to pay the ABSD of 12%, you have to ensure that you have successfully sold your place to a buyer buying your place, and that buyer must have exercised the option. Right?
That's correct.
Yeah, and because when you proceed to buy your next property and you make an appointment with a law firm for the purchase side, they will actually ask you for the exercise OTP of your current property to prove that you have actually sold the place. Yeah, if not, you have to pay the 12% ABSD. Okay, so the question comes here: what if you're doing a concurrent selling and buying? The selling part, you're selling a private property, you're buying a bigger private property. You have received 1%, your law firm has received 4%, and then there's a 12-week completion here.
Correct.
And then you went ahead and buy a private property resale. You pay 1%, you exercise 4%, and there's also a 12-week here. But in between, something happens for this deal.
Correct.
Right, and then let's say the buyer cannot complete due to several reasons, they backed out or whatever it is. What is going to happen here? Do you then have to back pay your ABSD?
Okay, straightforward answer. All of this comes from IRAS. Simple answer is yes.
Okay.
Yeah, simple answer is yes.
Right.
And the next question that logically comes up is, what can you do?
Yes.
From there.
Right.
So it's a very messy sort of scenario.
Right.
So theoretically, okay, you can go back to the person who bought this unit that you were selling.
Right. This property, right? Okay.
Okay.
The buyer that backed out.
Correct.
Okay.
Correct. And theoretically, you can say, hey, look, you have caused me this amount of loss because of what you did.
Right.
I'm going to ask you back for this whole amount of money. In theory, okay?
In theory, as in,
In
you
theory.
can ask them for the ABSD.
Yes.
Right. Okay.
Okay. In theory,
That means
you can
it
claim
will be
this
a
as
legal
loss.
suit.
Yes.
Right. Okay.
But practically speaking, it usually doesn't happen.
Right.
Practically speaking, because suing people costs money.
Right.
Okay, it's not like Suits or.
All right. Yeah.
Yeah.
Cannis watched the show as well on Netflix, Suits. Yeah. So if you have not watched it, it's a show about the life of lawyers and stuff like that. All right.
If only life was like that.
Okay. All right. Yeah. And yeah. Please continue. And then practically,
So
it's going to cost a lot.
Yeah, practically it doesn't usually doesn't work out, even if it's for a large sum of money, because the entire litigation process it starts with something called a writ of summons, okay, whereby you summon both sides to basically discuss this this matter before the judge.
Right.
But the entire process is very time consuming.
Right.
Okay. The other side can always drag out the process.
Right.
Okay. And it can take a long time, and all of that requires money.
Right.
And even if you win, okay, there is the next stage. When you win, you think that's it.
Right.
The process has ended. I'm going to get my money.
Right.
Then that's where your lawyers will tell you, there's something called enforcement proceedings.
Right.
Which means that if he is not good for that 100,000 or 200,000 that you have successfully managed to sue him for, you still are getting nothing.
Right.
So that's part of the process. So what usually people stop at is I take that 5%.
Right.
Okay, I forfeit your 5%. I make vague legal threats.
Right.
Okay. Which usually will not be substantiated. And then thereafter you try and mitigate the circumstances. But usually what will practically happen in those type of circumstances that you described is that the first sale will fall through. Right. Okay. And then the 5% will be forfeited. Right. And then after that, on the other purchase, okay, that you're making, usually the other side will also retain the right to forfeit that 5% that you have paid. Right. Yeah. Right. So if that is the sort of situation,
understand.
The practical side of it is tough luck.
Right. So unless you're willing to go ahead with the purchase
and pay the ABSD,
you pay the ABSD, and then you take that 6 months to quickly sell your property and find another buyer, and you forfeit that 5% and you move on. Correct. Right. That's the alternative way. Correct. Right. And usually when this kind of situation occurs, because you have already submitted your exercise OTB, but now that deal is now void. Correct. Is being made now. Correct. You should, I mean, as your own responsibility, inform your law firm, because sooner or later, IRAS definitely will find out and stuff like that, right? Correct. Yeah. So usually, like, what is the timeline? You know, like the moment you found out, I mean, you gotta quickly inform your law firm and stuff like that. Or usually, what's your advice? Okay. In these type of instances, right. You can it's not okay, because the law on it in relation to IRAS is that IRAS has the right to impose up to a penalty of 4 times of whatever amount is owed. Right. Okay. So in these type of circumstances, in that precise scenario that you described, usually what will happen is that IRAS, if you are going to back out from the purchase, IRAS will give you time, and they will even refund you back, okay, any initial stamp duty you have paid. Right. Okay. Right. So they will not penalize you on top of that. Right. But if it is a case of you are continuing with the purchase, IRAS will charge you some late interest. Right. Okay. On this. Right. Okay. And what will happen is that you'll need to top up the stamp duty. Okay. The 12%. The 12%. Right. Yeah. And pay that period of so-called late interest. I see. Then because technically you have not sold your property in a sense. Correct. I see. Unless you appeal and then you case by case basis. Correct. Okay. Got it. Great. Yeah, I think that's great information because
Yeah.
especially at times like this with the ABSD imposed,
Correct.
there's also a LTV limitation if you're doing selling and buying. A lot of people definitely wants to make sure that their place is properly sold and exercised before purchasing, right? So I think these are probably scenarios that a lot of people will find out. Now, the next question is that what happens is that let's say if you are a buyer and then you buy a property, you paid 1%, you paid the 4%, you paid the stamp duty, and then halfway into the completion phase, suddenly the seller do not want to complete the deal. I mean, what is what is your recourse as a buyer,
Okay.
right?
That you are in a much better position.
Okay.
Okay, your lawyer will be very happy also.
Okay. Why is that so?
Okay, especially if they have a litigation department. It is because in those circumstances, you can when you are the buyer, you
Right.
can complete the process.
I see.
Okay, the seller might say, I don't want to sign off on anything.
Right.
Okay, they can make whatever allegation that they want. Okay, but for because sometimes law is not clear cut.
Right.
But in that particular instance that you mentioned,
Right.
the law is very clear cut.
Okay.
All that happens is that I go to court. Okay, I ask for an order of specific performance
Right.
to complete this purchase.
Right.
Okay, the court will sign on. Will either give an order.
Right.
Okay, saying that the registrar will sign on behalf.
Right.
Okay, of the seller
Right.
to complete this transaction.
Right.
It's a very clear cut process.
Right.
And always what happens is that the seller lawyer will know that it is a very clear cut process.
that-
There is virtually zero chance of resisting.
Right.
Okay, such a matter.
Right. Because the seller has agreed the bank the 1%, 4% has been paid, stamp duty has been paid and stuff, right? So it's like almost 100% the buyer will win.
Yes.
Right. Understand. So this is the part that you said is very clear cut.
Yes.
Right. Okay. And that's how the law protects the buying of properties
Correct.
in Singapore. Okay, great. And how about I think relating to the caveat emptor clause, right?
Yes.
As is, where is condition and stuff like that. You know, when buying a property, especially a resale property, because private property is a very simple process. And very thankful we're in Singapore where our law is strong, right? And when we buy a property, there's confidence in buying because the law protects everybody. But sometimes, we have heard cases. I mean, we've been doing property for 14 years. Sometimes we've heard cases like, when a buyer takes over a property, resale property, and then when they go to their law firm and collect the keys, because technically after you pay the 1%, the 4% is being paid at the law firm. And after which, usually, if you do not arrange for any appointment to take measurement, bring your contractors, you don't really get to see the property. Right?
Correct.
So you collect the keys on the completion day at your own law firm.
Yes.
And then after that, you head to your new place or one other place. And sometimes they say, hey, the aircon is gone. Like some of the sellers has removed the fittings and the fixtures, some of it. The oven is gone and stuff like that. Right. So usually when this kind of things happen, two questions. What can be done as a buyer? And of course with the buyer's representing agent to protect themselves. Number two is that what is the mode of recourse from the buyer's point of view?
Once again, you hear this phrase from me very often.
Balancing.
What is the legal? What is your legal right? And what is the practical recourse?
Right.
So the law is actually also quite clear.
Right.
So if you remove fixtures from the place, the buyer must agree.
Right.
And fixtures are basically anything that's bolted down.
Right.
Okay, you cannot if you cannot remove it without a screwdriver, it's a fixture.
Right. Right.
So basically that's the legal stance on it. So but the practical side of it, for some buyers, you might very much I'm going to tear down everything anyway.
Right.
So if that's the case for you, practically speaking, it might not be of any concern.
Right.
Okay, but if how should I put this? You purchase this property on the pretext that or on the assumption, I wouldn't say the pretext, the assumption that it's very well fitted. I can just literally move my suitcase in,
Right.
and immediately start staying, and then it doesn't happen,
Right.
when you actually get the keys,
Right.
then that's when you can have recourse.
Right.
Yeah.
Right.
But then once again, it's about cost.
Right.
Is it going to be worth your while
To pursue it.
to pursue this?
Right.
Because my favorite phrase is, sure, you absolutely have legal rights
Right.
in this matter,
Right.
but do you want to pay me $3,000 to get back $300 for you? I'm fine with that.
Right.
Yeah, but you have to make a judgment call
Right.
whether you are fine with undergoing such a process.
Right, because it will be then a separate kind of representation apart from the conveyancing process.
Correct.
Right, to seek for recourse and stuff.
Correct.
Okay, right. So in knowing this, right, that what could happen, what are some of the best practices before putting down the 1%? I mean, usually we advise our buyers that when we represent our buyers, we will do a inventory list. We'll request for
Correct.
inventory list
Correct.
from the seller or the seller's agent,
Correct.
just to note down what are the fixtures, how many aircons are there, how many wardrobes are there, kitchen cabinets,
Correct.
oven, and cooker hood and stuff like that.
Correct.
So probably taking some photographs and stuff like that with the seller's permission. So what are kind of best practices, I mean, would you advise like buyers when buying resale properties?
I think you do a fair amount of HDB cases also.
Right.
So I think I'll actually be referencing some of the practices.
Right.
And which make a lot of sense, but
Right.
sometimes it doesn't happen for private property.
Right.
So for example, having maybe a viewing, okay, 2 or 3 days before the matter completes,
Right.
just to assess the situation of the property.
Right.
That would actually be a very good practice.
Right. That means to request for just a final inspection or
Correct.
something.
Before.
Right. But it will be important because if this request is not being put forth at the offer stage,
Yes.
the seller has the right to reject, right?
Correct.
Yeah. So usually I think it would be good to indicate in your offer to purchase letter
Precisely.
and request for it to be indicated into the OTP itself. Right. You're right.
Because it's not it's not a right.
Right.
Okay, it is it is a hope. you know.
Right. Right. So it's better to be black and white.
Correct.
Right. Right. So asking for a final completion by indicating down in the OTP it will definitely help. Right.
Correct.
So I mean, your recommendation is about 2 to 3 days before completion. So at least you can
Yes.
sound out to your law firm.
Correct.
Right. Okay. Good.
And the limitation that we as the lawyers always have is that if it is stated within the option,
right.
we can tell the other side, it's stated within the option. You have no choice.
Right.
But in most cases, this inspection clause will not be found anywhere within your standard option.
Right.
So
Right.
that will be the limitation.
Right.
That
So
will
you
be
have to
struggling against.
intentionally
Correct.
discuss with the seller.
Correct.
Right.
And then also sometimes it's not out of malice, because sometimes the seller will also be, hey, I'm busy, or hey, I mean you
Right. It's common. Right.
yeah, okay. Or what if suddenly they raise some allegations that this should be here or this should be there, then I'm bringing trouble onto myself.
Right.
So ideally, all of this, if it can be worked out at the start, lah.
Right.
Yeah,
right.
but of course that's easier said than done, lah.
Right. So it's all part of the negotiation, and of course, from the seller's point of view, is that sometimes sellers also hear horror stories, right?
Yes.
Sellers also are worried because when sellers sell a private property, sometimes
Correct.
they are worried. The buyers request for a final inspection 1 to 2 days before that.
Correct.
And then they heard horror stories like the buyers start to pick on things,
Yes.
like saying, hey, there's this, there's that, and then they want to delay completion and stuff. So
Correct.
I think end of the day is important. Communication is important,
Yes.
which is before the 1% is paid. You have any kind of doubts and concern, I think it's important that you put out during the negotiation phase so that the whole transaction becomes
Correct.
smoother in the sense.
Correct.
Right.
And one other thing I think I want to use this opportunity to, since we're talking about this stage, to flag out is that because your lawyers generally want to complete the matter.
Right.
Okay. Because they've got other stuff to do. Okay. So no, but part of it is because any conveyance is a matter of timelines of everything else happening at this date.
Right.
Your CPF, your redemption, a lot of things are supposed to happen at this date and no other date.
Every dollar and cent is counted to
Yes.
the dot, right?
Correct.
Right.
So what happens sometimes is that things happen. People want to change the date in which they want to complete this matter.
Right.
So it's like, come on, it's a simple request. I just want to change the completion date by 3 days or by 1 week.
Right.
Then that's when we saw like, oh my goodness.
Right.
Yeah.
But all the calculations would then have to be recalculated and stuff.
Recalculated.
Inform the bank, inform
Correct.
CPF board and stuff like that.
Correct.
Right.
So that I think is part of what the substance of what we have to deal with. Okay, and yeah. And so
Right. So I think what Cannis is saying is that all parties are motivated to complete
to
the
complete
deal.
the matter.
Right.
Yeah.
Okay, great. Yeah. So I think we have answered some great questions pertaining to buying a property. Now, from the seller's point of view, I think just now we have cross-answered a little bit about the seller's
Correct.
portion as well. I think one very important thing that a lot of people have overlooked is the seller's stamp duty
Correct.
when they come to selling a property, because yes, although now the seller's stamp duty has been reduced to 3 years.
Correct.
If you buy after a specific date and month in 2017, but of course this will be the last year that some sellers will still be within that 4-year seller stamp duty thing. So sometimes when some sellers want to sell their property and they sold it successfully within the seller stamp duty period, whether they have to pay the 4% or the 8%, this seller stamp duty actually has to be paid the moment that the buyer exercised the option. Am I right to say?
Within 14 days.
Within 14 days, right?
Same like your any stamp duty.
Right. And as a seller's point of view, it's different because technically you only get all your proceeds at completion.
Yes.
Right. But you receive the 1%, the 4% is paid to your law firm.
Correct.
And they are your stakeholders, CBY account. And then within 14 days, you have to pay the seller stamp duty. So
Yes.
it could be 4%. If it's like 2 million, it's going to be 80,000.
Correct.
If it's 8%, it's going to be 160,000. And that has to be paid in cash.
Correct.
Right. And by that time, probably your funds is only coming out in another like 8 to 12 weeks time.
Correct.
Yeah. So this is something that I think a lot of sellers has overlooked. Right.
Correct.
So in regards to this, what are some of the common like practices, like what if the seller fail to pay this? What's going to happen to them?
Okay.
Right.
They cannot complete the transaction.
All right.
Yeah.
Right.
If seller stamp duty is not paid,
Right.
and we know that it needs to be paid,
Right.
the transaction cannot be completed.
Right.
Okay. So ideally, this is spotted at the start of the transaction.
Right.
So what usually you do is that you try and negotiate for example, let's say it's only 4%.
Right.
Okay, because it's 12.84. So and hey, 4% of exercise monies, and usually when you are selling, even when we are in a push to sell it, usually it's in that last year.
Right.
So what some parties do is that they negotiate for this 4% to be directly paid to the Commissioner of Stamp Duties.
Right. Okay.
Yeah. So
Right.
so within your option, you can actually amend your option to specifically state that pay this 4% made payable to the Commissioner of Stamp Duties.
Rather than your law firm
Then the law firm
dash
or whatnot.
CBY account.
Correct.
Right. Okay.
So
and
this can be contracted for.
this can be contracted for.
Yes.
Okay. And that brings us to another question, pertaining back to the buyer side, because sometimes when buyers buy a property in the resale market,
Correct.
and during the negotiation, actually the seller will then request of course, in terms of good faith,
Yes.
it's a genuine matter, because some sellers, they are also in the midst of selling and buying a property.
Correct.
And sometimes they need that 1 and 4% to be paid
Correct.
to them, so that they have this to
Correct.
go down pay.
What
and
is the
stuff.
risk?
Yeah, so some sellers will then request for the 1%, naturally is by market practice to be paid to the seller's name, 4% to the seller's law firm dash CVY account.
Correct.
Some sellers will request for that 4% to be paid directly to their name. right? So as a buyer's point of view, and of course, in terms of your advice to sellers, is that widely practiced in the market? What are the risks and the pitfalls, and what are things that the buyer and seller have to look out for?
Okay.
Right.
The standard industry practice is actually you pay this to the law firm's conveyancing account.
Right.
That's industry practice. But once again, if there are special circumstances and you can agree on it, then carry on. So what is the risk to the buyer?
Right.
Okay, if you immediately issue all of these monies direct in favor of the seller,
Right.
or even to stamp duty or whatnot.
Right.
Okay. The theoretical risk is that what if it is something called a negative sale?
Right.
Okay. In the event of a negative sale, it's very bad.
Okay.
Okay. Because it could be potentially a situation of, let's say you have contracted to buy this property for 1 million.
Right.
Okay. So at completion, okay, the seller will tell you, look, okay, I owe 1.2 million. Okay.
Right.
I owe 1.2 million to CPF board and the bank combined.
Right.
Okay. so the 5% that you have paid to me, thank you.
Right. Right. Because at completion, the seller's law firm will actually ask the seller to vomit out the 5%.
Correct.
Right. So that to complete the accounts.
Correct.
Right? And if they can't do that, then the deal cannot be completed.
Correct.
Right. And then will the whole case be stuck in a limbo? And
Sorry, it will be stuck in limbo.
right.
So if you are the buyer, it's like, oh goodness, okay, because as a buyer, you have also signed contracts.
Right.
You have signed contracts with the bank
Right.
to borrow a certain X amount of money.
Right.
And so you have contracted to buy this place at 1 million.
Right.
So being told that, do you want to pay for him another 100,000 or 50,000?
Right.
Usually will not exactly be on the cards.
Right.
Yeah.
Right.
So, but that might be a practical situation that might arise if you are basically buying
Right.
a property, okay, that basically owes more money than it's being sold for.
Right. Right.
So-
So the tricky part will be when it is a negative sale.
Negative sale.
You're
Correct.
unaware of,
Correct.
and you actually agree to pay this 5% directly to the seller.
Correct.
So the potential risk is that you might be stuck in the limbo situation.
Correct.
Right. So
So
your advice is that at the best circumstances not to do that
correct.
as a buyer.
And but always, I mean, similarly, to switch it around on the other foot, okay,
Right.
what can you, if you're the seller and you want this,
Right.
what reassurance can you give to the buyer?
Right.
So usually what you do is that you show them evidence that, look, I only owe, let's say we use the 1 million example again.
Right.
Okay, I only owe the banks on this 500,000. See, this is the
Right.
loan amount with
Right.
the bank. Okay, I only owe CPF board in relation to this property.
200,000.
200,000.
Right. So
It's very safe.
right.
Yeah.
So I'm going to get like 300,000 cash.
Correct.
Right. And this 5% that you pay me in advance first, definitely it will be honored. And stuff,
Correct.
right. Because they don't have to vomit it out during
Correct.
completion. Right. Okay, great. So there's some practices that the seller can actually do to reassure the buyers. And
Correct.
stuff. Right. Okay, great. And what if I think we have already answered, like if the buyers agree to pay the 1% check and then they didn't honor, you can actually recourse it as a
Correct.
seller, because the law also protects the seller in this manner.
For that very short period of time.
So if let's say you are selling your property, you receive a 1% check and then you're banking in, the next day you realize that it is not honored, you have to immediately
take action on
take
it.
action, inform your law firm
Yes.
so that they can seek for recourse
Correct.
ASAP, right?
Correct.
Okay. So and then you mentioned the time frame is usually
Days.
a few days, right?
Yes,
Probably
a
1 to
few
3
days.
days.
Correct.
Okay, great. Now, I think Cannis has helped us with a lot of questions regarding to the buying and selling, and these are really technical questions, but these are great because it covers a lot of blind spots, especially when we are doing selling and purchasing and things like that. And I think what we're really interested in is also, in recent years, a lot of property buyers, because of ABSA and all that, they have started to use this trust kind of concept to purchase properties, so-called under their children's name, and then when their children turns 21 years old, the property is like a gift to the kids, right?
Correct.
Yeah, so we just want to understand a little bit more about buying properties in trust.
Okay.
And what are some of the pros and cons? And there's some questions here and there, like can you take a loan and stuff like that. So probably I'll just kickstart with the first question is that when let's say somebody have a couple, they already have like 2 properties,
Yes.
right? One in each name, and then they have 2 children. They are both below 21. Let's say the kids are like 10 years old and 3 years old,
Correct.
10 and 3. And they decided to buy a property under the 10-year-old child.
Correct.
This child will be named as the beneficiary.
Yes.
And then the parents will be named as the trustee.
Correct.
Right. Can they take a loan on this property? Let's say the property is $1 million. Yeah. Can they take a loan?
No, they can't.
So it has to be full cash.
It has to be full cash.
Okay, so full payment for the child.
In cash. You can't even use CPF.
No CPF, no loan, is full cash.
Yes.
Right, okay, great. That answers the first question. Now the second question is that when they buy this property, let's say now we're year 2020.
Correct.
They buy this property under the 10-year-old son. When can they sell the property?
Okay. I'll be frank on this point, okay?
Right.
Because there are 2 different schools of thought
Right.
on this. One school of thought says that only after the child turns 21, then you can sell this property.
Right.
Okay. I don't quite agree because I don't quite understand
Right.
okay that school of thought at all.
Right.
My school of thought, which I sort of follow along with and practice, is basically 5 years.
Right.
And how do I derive this application?
Right.
Okay. Simply put, because of the application of Singapore's bankruptcy laws.
Right.
So what it does is that all of these trust transactions are in a way quasi gift transactions.
Right.
So how it works is that if within 5 years, if one of the trustees who created this trust goes
Right.
broke,
Right.
technically the entire transaction can be unwound.
Right.
So there is this
Unwound
5-year.
meaning like
That means the creditors can say, no, this transaction, this gift transaction that you have done, this trust that you have created, is not valid.
I'm going to use the money.
To pay me as your creditor.
Right. I see. So because of this, the usual minimum time frame,
To us, it's 5 years.
you have to hold on to that trust account, that property
That property for 5 years.
for 5 years. Then you can sell.
Correct.
Okay, what happens to the money after you sell it? Does it go back into the trust account or will it go back to the trustee?
Okay. This once again, it's very much what is the legal position?
Right.
Okay. Because practically I can't control what you do thereafter.
Right.
Okay. So the legal position is that all of these are irrevocable trust
Right.
instruments.
Right.
So what it means is that theoretically, even if you sell this property,
Right.
it should flow back to the trust fund,
Right.
okay, and be used for the benefit and welfare of the child.
Right.
Okay.
Right. So that means after you sell the property,
Correct.
the money goes back to this special account called the trust fund account,
Yes.
and the beneficiary can have full access and rights to it when they turn 21.
Yes.
And during this period, I mean, like as a parent, am I able to use the money? Or I can't use it. I can't touch it. It's locked.
Okay. Generally, it depends on how your trust deed is drafted.
Right.
Okay. And 2, theoretically, do you think your child is going to give you any issues down the road? Okay. Once again, there is not a lot of law on this.
Right.
Okay. Because the incidence of 21-year-old beneficiaries gathering a legal team to sue their parents, somewhat small.
Right.
Yeah. Right now, 0.
Okay. All right.
So generally, how we draft our trust deeds is in relation to the fact that you have certain powers, okay, to deal with all of these trust monies,
Right.
okay, for the benefit and welfare of the child.
Right.
Okay. The theory is that the only one who can theoretically hold you to account, right now as of law,
Is your child.
is your child.
Oh, I see.
Okay.
It's because it's like a agreement between the trustee and the beneficiary.
Correct.
Right. Understand.
So if your child says, please give me an account of how you have spent this 1.2 million after you sold this property. Theoretically, you have to give them that account.
Right.
Okay, of how you have spent this 1.2 million.
Right.
But what we always so usually the clients, when they hear this, they get a bit alarmed. But then that's when we usually quip to them that you do realize that bringing a child up to 21 is at least $1 million too, as of fact.
Right. Understand. Okay, great. So, technically, you as a trustee, you have access to that account,
Yes.
and you can use it to, so-called like, run the. Let's say if you do rent out the property and
Correct.
stuff like that, you run expenses and things
Correct.
like that, right? So, how about the rental money? Theoretically, it has to go back to that account
Yes.
as well. The rental income, and
Correct.
things like that. Okay, great, got it. And what are some of the important things that that the trustee have to take note of, other than the 5 years, other than the fact that if you were to hold that property all the way until your child turns 21, the property goes directly to your child. What are some of the probably like your advice usually to parents and things like that using this facility?
Okay. It depends on the individual,
Right.
to a large extent. Because some enter this arrangement with a strict view to, I'm going to sell it within 5 years.
Right.
Okay. Then thereafter that, I'm going to use it for the benefit and welfare of my child.
Right.
Okay, be it university education or whatever it is. So that is one of the strategies.
Right.
So sometimes for others, it is I'm just going to sell off everything, and then
Right.
thereafter that I'm going to reinvest.
Right. Buy another
Okay,
property.
buy another property.
Right.
So it really depends on the individual,
Right.
how they deal with it.
Right. What's your goal
Yeah,
and your objective
Correct,
and
correct.
stuff?
So
Okay.
I think it's always very important to be very clear about what is your goal and your objective.
Right.
Yeah, before you proceed.
Right. Understand. Okay, great. And I think that would definitely help answer a lot of questions about using trust as a facility. I think end of the day, the main objective is really to use this as a gift for your kids, right?
Correct.
And to leave
It's
like
about legacy planning.
it's a
and-
legacy planning and
all
leave
that.
something good for them.
Correct.
Right. Okay, great. And actually, we still have a lot of questions regarding the property transactions, but I think today's session is really great, and we have answered key questions about buying, selling, about trust. And we actually love to have Cannis back on our Property Brothers podcast because we have further other questions as well. We also have questions relating to rental kind of transactions, some common legalities between landlords and tenants and stuff like that. And I think we're going to have episode 2. We're going to have Cannis back on our show again. And but for today, I think this will be fantastic and very beneficial. So before we let Cannis off, right? So Cannis, do you have any just final advice for buyers and sellers out there today in 2020? Usually, what are some of the things that you have seen a lot during your past 10 years of experience? Like, some key thing to take, maybe just some takeaway for all this.
Okay, one of the key takeaways for me.
Right.
This is perfectly anecdotal, of course. I remember 10 years ago.
Right.
At a time I was walking into a show flat
Right.
with my then girlfriend, now wife.
Okay.
So we were going in and we're asking, hey, looking around. I bought a HDB, so
Right.
so we were asking around and we're saying, hey, is there anything under $1 million?
Right.
From the show flat.
Right.
So or around $1 million.
Right.
That was 10 years ago.
Right.
So they were like, sorry lah, don't have.
Right.
Okay.
Right.
So now, fast forward 10 years.
Right.
I think if you go into any show flat and ask, do you have anything that's good, decent size, 3-bedroom that's under $1 million? I think you might get laughed out of the place. So I think, yeah. So, I think property investments is still one of those things that are still very much worth doing. you know.
Right.
And I wish I had done so earlier 10 years ago.
It's still not too late now. Right. Yeah, I think for the fact that we're in Singapore, I
Yeah.
mean, our land is so small
Yeah.
and population is increasing, and at the same time, of
Right.
course, there's inflation, there's construction costs and land prices are increasing as well, right? So, so 10 years back and today, right? Okay, great. And we're really honored to have Cannis with us. Yeah, so he's shared a lot of insights, and I think this session have benefited you. So we welcome you to leave any comments or any questions that you have right down below, and then so that we can, when Cannis come back for a second round, we can actually ask him in person again. So thank you so much again.
Okay.
Yeah. So a shout out to everyone. This is Cannis Seng from BR Law. All right. So we also put down his firm's website down below. You can check out his company information and stuff like that. If you need any legal advice, do give him a call, to reach out to them. All right. So thank you for watching our PropertyLimBrothers podcast, and we're right here in our studio, and we hope to see you soon on the next episode. All right. I hope you guys enjoyed this episode of our So Far So Good podcast series with PropertyLimBrothers. Now leave a comment down below and let us know your thoughts about today's episode, and